We have with us Mr. Timothy Jonas, Senior Counsel, who has graciously agreed to contribute to our learning in the area of contract law, with specific focus on remedies for breach of contract. Mr. Jonas, there are two main remedies for breach of contract, namely damages and specific performance. The issue that arises in damages tend to center around the principles used to decide what type of damages to award, rather than how the precise figure to be awarded, that is, arrived at. What is the principle behind the award, and how does the court in Guyana approach this?
Well, I'm not sure how much you're going to learn from me off the top of my head, but I'll give it a shot, because I promise you as a favor. Contract law is peculiar because the rules are set by the parties themselves. The parties decide the terms of the contract that they will be bound by, and can even include exemption clauses, forgiveness clauses, waiver clauses. But when there is a breach of contract, the underlying principle for the award of damages is that the party must be compensated for his pecuniary loss which he has suffered as a result of the breach. The loss must be foreseeable, it must be understood by the parties. If someone was looking at it, he must be able to anticipate that this would be a category of loss suffered. And an important ingredient is that you don't get damages for your hurt feelings where you've breached a contract. There is an English judge who said contract law is a hard matter of dollars and cents, not hurt feelings. Now, damages in contradistinction to specific performance is available to remedy the pecuniary loss, but there are instances where a court, instead of awarding damages, will allow a litigant to get an order mandating that the defendant specifically perform the contract which he has breached. The underlying premise for an award of specific performance must be that damages is not an adequate remedy. So the question arises, when will damages not be an adequate remedy? And the general rule of thumb is house and land. Most chattel, most movable property can be replaced. Somebody damages your car, or somebody breaches a contract for the sale of a car, chances are you could buy another car, so damages will be an adequate remedy. Land, however, cannot be breached for lot 21.
Correct.
There are a few exceptions, and off the top of my head, I remember Leaf and International Galleries, where specific performance was awarded for breach of a contract to sell a painting, the work of art being considered unique and irreplaceable, and therefore akin to a piece of land. It wasn't something that I can compensate you and you can go and buy another painting. That painting was of itself irreplaceable, and therefore an award of damages for the breach of the sale contract would not have been an adequate remedy. But generally, your rule of thumb is house and land.
Excellent. What about rectification of contract in equity? Does the court, given our oral tradition here in Guyana, has to utilize this very often?
Well, rectification of a contract is an expression I don't like. Contracts can be written, they can be verbal, or they can be by conduct, as you know. The question that arises evidentially when you are in court, and I know you're not in court yet, you're still doing your first degree learning the general principles, is what does the court have before it in terms of evidence to decide what are the terms of a contract? It's easy if the contract's written. You put that piece of paper in the court's hand, the court looks at it, sees the terms. It may be that the terms are ambiguous. It may be that the terms are self-contradictory. In a case of ambiguity, a court is not easily permitted to invent terms for the parties. So the court may imply terms. The implication of terms, as you know, is based on the two issues, the officious bystander test, what is obvious to the officious bystander, and then what is necessary for business efficacy. Those are the two common sense approaches for implied terms. I don't like to go beyond those.
Correct.
So when you talk about rectification, you're suggesting that the court is going to be introducing new language that possibly hadn't been contemplated by either party at the time. And I don't like that approach as a discussion of contract law because it introduces something that is
That's new
very
one.
narrowly dealt with.
Yeah. What about rescission? I mean, in your practice, have you ever had to deal with rescission of contract? And can you give us a synopsis, if you may, and what was held?
Okay. The rescission of a contract is something that you do at your own risk. Time passes, you enter your contract, you agree on buying a piece of land from you, and you agree that you'll pass transport in 3 months. And 3 months comes, that's technically not right because you make the decision that you are treating that contract as at an end.
Mm-hmm.
And either you're right about it or you're wrong about it, you don't know until you get to court.
Right.
But you are entitled to treat a contract as rescinded if the other party has breached a fundamental term, a term that is important enough that the gravamen of the contract has disappeared and therefore there's nothing left and you can walk away.
Right. But can a party lose a right to rescind?
If the party who is in breach corrects that breach and the correction of the breach is accepted by the other party, then you have waiver.
Right.
Or acquiescence, which is a close cousin of waiver, where you begin to perform the contract and the other side doesn't do anything about it, so he's acquiescing in your conduct. Then you can, by your conduct, have said to have waived or acquiesced in the correction of the breach, and therefore you become bound by the contract.
Excellent.
So it is a question of equity.
Oh, equity. So, lastly, do you think that jail time should be a remedy for extreme case of breach of contract?
Definitely not. Let me tell you, Charles Dickens' father, you will, I hope, have read Oliver Twist
Yes.
and the other Dickens novels. But Charles Dickens' father died in debtor's prison. Debtor's prison existed 200-300 years ago, where the law allowed a proven debtor to be imprisoned until such time as he paid his debt. Now, if you're in jail, how on earth are you going to earn money to pay your debt? So, a lot of, especially in the patriarchal system that existed 300 years ago, 200 years ago, where daddy gets locked up in debtor's prison, mommy can't get a job,
Everybody
and the
suffers.
children are thrown in orphanages. And Charles Dickens actually spent his time growing up in poorhouses and orphanages until he started to make his own dollar.
Right.
You can't interfere with someone's liberty and conflate issues of dollars and cents with a question of a person's liberty. If they can't pay, they can't pay. And the court system is designed to avoid, to prevent you from evading. But if you have a judgment against someone for money, for breach of contract, and you can't find their assets, who does it help to lock them up? It doesn't help you, it doesn't help the state got to pay for them, it doesn't help their family, and
nobody benefits.
no one benefits.
Thank you very much, Senior Counsel. It's quite an inspiring
Glad
talking
to
to you. Thank you so much.
All right. Now, if you're in jail, how on earth are you going to earn money to pay that? So, a lot of, especially in the patriarchal system that existed 300 years ago, 200 years ago, where daddy gets locked up in debtor's prison, mommy can't get a job,
Everybody
and
suffers.
the children are thrown in orphanages. And Charles Dickens actually spent his time growing up in poorhouses and orphanages until he started to make his own dollar.
Right.
You can't interfere with someone's liberty and conflate issues of dollars and cents with a question of a person's liberty. If they can't pay, they can't pay. And the court system is designed to avoid, to prevent you from evading. But if you have a judgment against someone for money, for breach of contract, and you can't find their assets, who does it help to lock them up? It doesn't help you, it doesn't help the state got to pay for them, it doesn't help their family, and
nobody benefits.
no one benefits.
Thank you very much, Senior Counsel. It's quite an inspiring
Glad
talking
to
to you. Thank you so much.
All right.
What is specific performance? Specific performance is an equitable remedy available under the law of contracts. In a nutshell, an order for specific performance would be the court compelling or forcing a party under a contract to comply with its obligations under that contract. So if party A and party B contract to do X, and Party A fails to do X, Party B can take him to court, and the court can say, Party A, you have not done what you have said you would have done under this contract, and I am making an order that you must do what you said what you contracted to do under that contract. Specific performance is awarded only where the court finds that damages alone would be an insufficient remedy. And you'd usually find that in cases where the subject matter is something that is unique, or for example, in sale of goods, you'd only find it if the good of itself is something unique, like some antique or land. So in Guyana, you will find that a lot of the time, specific performance is awarded in cases dealing with the sale and purchase of land. So Party A agrees to sell to Party B a piece of property or a piece of land. Party B has